All right, Representative Willard on your bill, sir. Oh, hold up, we need to read it in.
Okay.
Ms. Firegrass, can you read in the bill, please?
Thank you, Mr. Chair. Members, this is House Bill number 333 by Representative Willard to provide for certain rights for applicants, to require disclosure of certain information, to limit liability of housing providers in certain circumstances, to authorize penalties, to provide for an effective date, and this is relative to lease applications for residential property.
Representative on your bill.
Thank you so much, Chairman Deschanel and members. I appreciate your attention to this matter. I know you're short on time, so I'll be as brief as possible. Before I try to set the stage for why HB 33 is needed and give you some information on what the bill would actually do, I want to read you a couple of sentences that came from HUD when they released guidance related to the Fair Housing Act at the federal level. Those sentences say, arbitrary and overbroad criminal history-related bans are likely to lack a legally sufficient justification. Thus, a discriminatory effect resulting from a policy or practice that denies housing to anyone with a prior arrest or any kind of criminal conviction cannot be justified, and therefore such a practice would violate the Fair Housing Act. That kind of sets the stage for HB 333. I'm sure most of you are aware that Louisiana has one of the highest incarceration rates in the world. What you may not be aware of is that about 1.5 million adults in the state of Louisiana live with a criminal record. Today, you're going to hear from some of those residents of our state. You're going to hear about their struggles as it relates to finding secure housing. You'll hear about their pain and their sorrow, and it stems from two main issues: application fees and background checks. More often than not, when these men and women go to apply for an apartment, they must have a background check ran, and they must pay an application fee every time. When denied, they must go to another complex and have a separate background check run and pay a separate application fee. Again and again and again. Application fee after application fee after application fee. And sometimes those fees can be more than $100. More often than not, when these individuals go to get housing, they are not aware of why they would be denied. Even more rare is they have no idea if the provider considers arrests that did not lead to convictions, if they consider a certain time period, a look back period, and many times they don't even know that they were denied. So in desperation, these aspirational tenants, as I like to call it, have to go through and start this process all over again. Because how can anybody in this state, in this country, be successful if they don't have housing? How can they hold down a job if they can't find housing? How can a father raise his son if he can't find housing? HB 333 will give these men and women a better chance at providing a roof over the heads of their families. What this bill would do is allow applicants to know before they submit an application fee why they would be denied housing from this complex. They will know if the complex considers certain charges, if they run a background check at all. It allows applicants to demonstrate proof of rehabilitation or other mitigating factors. It allows them to contest inaccuracies in a background check. For instance, if I go, my background check could say Matthew Willard, bank robbery, but that happened to a Matthew Willard in Florida. And so this bill would allow them to say, hey, that's the wrong Matthew Willard. Here's my background check. Right now, it's up to the complex, and many times they cannot do that. This bill provides liability to housing providers if they rent to someone with a criminal record or if they do not run a background check, and it allows applicants to receive a refund of their application fee if a housing provider violates this law. Members, that is what this bill does. I think I laid out the reasoning for this bill. This is my third year. I know we have a lot of new members on this Commerce Committee. This is my third year running this bill. 2 years ago, I was able to get it all the way to Senate Commerce, where it died by 1 vote. Last year, I voluntarily deferred the bill. Heard from a lot of our colleagues that they didn't want to vote on this during an election year. I can tell you whether this bill moves favorable or not, this problem will continue to persist. And in a state where homelessness runs rampant in many of our large cities, not allowing people with criminal records to get housing exacerbates that issue in our state. I'm happy to work with any of you on any concerns you have, on any amendment ideas that you have, and I'm happy to entertain any questions that you may have. And to my right, I have Ms. Sarah with the Justice and Accountability Center to provide greater context to this legislation. Thank you.
All right, Ms. Sarah.
Yep. Good afternoon. Sarah Whittington with the Justice and Accountability Center. I'm also going to just provide some context and background that the Louisiana Fair Housing Action Center did through testing. And so they are a statewide nonprofit that looks at housing justice issues and fair housing issues. And they did a test in 2022 that sent mystery tenants or mystery renters to shop at 56 various housing providers in New Orleans, Baton Rouge, and Lafayette. What they found was that of the properties tested, which were all apartment association members, so these are members that would receive regular training and education on fair housing and rental policies and practices. Of the 56 tested, only 5 of them could provide an explanation as to what kind of criminal record would lead to a denial for a tenant. Additionally, the application fees that were reported by these testers range from $35 to $100, and there was often additional $100 to $150 in administration fees. So many times what this meant was that these testers, or if it was your constituents or residents, could be risking over $100 with every single application without knowing what could or could not deny them housing based on each individual provider. So of that as well, 1 of the properties allowed for a refund when the person was denied based on their criminal record. So what we can see from that is that there is a small percentage of housing providers, apartment association members, who will, in these tested properties, provide basic transparency around the criminal records and that application process. It also shows, though, that disclosing your criteria on the front end and what could be used to deny an applicant is already happening and is not overly burdensome on these organizations and businesses. And considering that someone with a record may have to apply multiple times over and over to be denied and restart the process, as Rep. Willard sort of explained in his introduction, is asking those individuals to potentially put at risk the safety deposit that they've saved, the first month or last month's rent that they've saved, in order just to find out if they are or are not eligible. So we will note that this bill does not mandate that anyone accept a tenant with a criminal record, okay? These people are not setting out specific requirements. It is that they must disclose the parameters that they use when looking at a criminal record. And then it will give the renters an opportunity to recoup those expenses if they are denied and they need to go apply elsewhere, so that they are not consistently and repeatedly risking the money that they've saved. Additionally, we would note too that in Louisiana, half of our population has some form of criminal record. And these are the consumers and the constituents in your districts. All right, we know 9 out of 10 landlords will run background checks. We know 1 in 2 children have a family, have an adult, have a parent with a criminal record as their caregiver. So this is not just about the individuals that are seeking housing. This is about family stability and about successful reentry. So what we would acknowledge is that what this bill will do is basically outline for individuals who have the funds set aside to actually apply for and be good, valid tenants in these places, to just be given an opportunity to know and understand the parameters before they walk into the rental office, before they put their money on the line and potentially lose that as a financial risk. I would also note as well that there is no correlation between a criminal record and your ability to be a good tenant and pay the rent. And what we will oftentimes see as well is that the background check companies that are used will give a blanket thumbs up, thumbs down without actually providing any context or understanding of what is correct or incorrect on your background checks. The majority of these records can be inaccurate, but more often they are incomplete. So it may show a bank robbery arrest for which that person was never convicted, and they are relying on insufficient and incomplete information when making that decision that in fact the person is a very good tenant, has a great credit record, would be paying rent on time, but for that one flag that is ultimately going to boot them. And we know that housing stability is directly correlated to successful reentry. So individuals with criminal records who are able to come home and either through family or through opportunities and just the goodwill potentially of their community, when they have stable housing, they're able to find stable employment, get access to the health care they need, and successfully reenter and have significantly lower rates of recidivism. And with that, I'm happy to answer any questions.
We do have quite a few questions. Representative Thomas with a question.
Thank you, Mr. Chairman. Representative Willard, you testified that you last year voluntarily deferred this bill. Is this the same bill that you deferred last year?
Yes, Rep.
So it's identical?
Yes.
Thank you.
Representative Knox.
Thank you, Mr. Chairman. I first have a comment and then a question. I want to testify myself and bear witness to everything that Representative Willard and Ms. Woodington stated. In a past life, I worked for the Department of Veterans Affairs Homeless Program, and part of my job was to identify housing for those homeless veterans. And a lot of times, we always came up against this issue. And it would be resident after resident after resident after resident paying these fees, already knowing the outcome. So I want to let my colleagues know that what you're hearing is no exaggeration. It's real. On the other side of that, I also own some rental property. And I know firsthand what it's like when you're trying to start all over again. I know what it's like when individuals who have been formerly incarcerated and paid their debt to society and trying to get on the right track and have all of these various barriers and obstacles to go through. And in my personal view, it just isn't fair. When you pay your debt to society, you paid your debt. And you should have a chance to a decent life and a decent quality of life. On the business side, my question as it relates to recouping the fee, can you give me clarity as to whether or not that is on the first charge or is it on subsequent, meaning that when the applicant goes and apply and they are denied based on their criminal history, does that first applicant or first application gets the refund, or does it become those subsequent?
So this will be on a case-by-case basis. So if this becomes law, if you're denied because you violated, if you're denied because of a criminal record and the provider violated this law, then they would do the refund.
If they violated the law, in what context, just for clarity?
If they didn't disclose what they deny for, if they didn't let the person know that they run a criminal record, there's one other.
So if they do disclose that they were denied based on a criminal background, they do not have to recoup
Correct.
or refund any
Correct.
application fee? Yeah,
the application fee refund is centered around violations of the new law that would be.
Okay, thank you. I got it. Appreciate it.
Yep.
All right, my dear friend, Representative Newell, with a question.
Thank
My
you,
friend
my
too,
friend, Mr.
sometimes.
Chairman. Or you claiming me today?
I always claim you.
You're so sweet. So, question. So the housing is the housing that does the housing. I don't want to say companies because it's not always companies, but wherever you're going to apply for the lease or the rent, the background check that they're looking for is it has to be expanded. They have to let everyone know exactly what is being looked at.
Not exactly. And I've, over the past couple of years, tried to work with the apartment association and the realtors to some extent on that issue. They didn't want their hands tied, so we tried to come up with language that would, still allow the intent of this bill to come to fruition, but also not tie their hands. So, if they wanted to say we won't rent to anybody with a violent felony conviction that occurred in the last 10 years, something like that. Okay. Right now, the issue is that, number one, when somebody is denied many times, they don't even know. There's no notification sent to them. If they do find out, they certainly don't find out why they were denied. And so if all you're getting is a blanket denial, if anything, of that you can't get an apartment here, you're going to keep trying, right? Because you need that housing, but there's no direction, right? So if they knew that, hey, I have this thing on my record that is going to bar me from random number, 60% of the properties in the city of Baton Rouge, I'll see if somebody can help me, maybe at the Justice and Accountability Center or the Fair Housing Action Center, that knows some place that'll take somebody with this conviction.
Okay, thank you. So like the Green Book for renting in 2024. So this bill would require that the reporting or the background check is more specific. So using your example, we're not looking at the Matt Willard bank robber of Iowa. And we're looking at the we're making sure that the background check is only for the Matt Willard of New Orleans. Well,
so we're not mandating any specific background check. We're not mandating
not a specific type, but I mean to be a detailed check so that it's not just looking for that blanket Matt Willard. We're making sure that it is the Matt Willard that is applying, and not
I'll give you
picking up a name somewhere else.
I'll give you a quick example of how it would play out, right? So let's say I go to this complex, I try to get an apartment, they deny me, they say, look, during your background check, we saw this bank robbery conviction, and I can say, well, I never robbed a bank. Can I see the background check? And then I say, well, that's not, I live in Louisiana. I've lived in Louisiana all my life. That person is in Ohio or Iowa. So that's a real life example of how it could play out, which right now we can't have. We don't have in many instances. There's no dialogue. Okay. So and in many cases, there's no alert that you were denied and why you were denied.
Okay, so it's now they have to tell them what it was and have that conversation so that any confusion could be cleared up. Okay.
Well, the provision that allows them to provide evidence demonstrating rehabilitation or other mitigating factors also allows them to basically contest inaccuracies in the background check.
Okay, great. And the fee that is paid for these background checks, does that go towards the security deposit, or is that a fee that's separate and apart from security and first month rent?
So believe it or not, the application fee actually became somewhat of a bipartisan concern over really in 2022 when I first ran it, because we essentially discovered that a lot of these complexes are banking the background fee, application fee as revenue. And so it doesn't have to go to anything outside of, they'll say it covers the cost of the background check.
Okay. And I'm glad you brought that up, because I wanted to ask, as follow-up to Rep. Thomas's question, if this was the exact bill from 2023, this is the exact bill from 2022 that did make it to the Senate side, correct?
I can't say that one, because in 2022, I was able to work with, actually a couple members on this committee and stakeholders on some amendments that kept the intent of the bill intact. and allowed it to, I guess, alleviate some opposition. So we were able to get it onto the Senate side. But what happened in that year is the goalposts continued being moving. So they would say, make these amendments, we won't oppose it. I made the amendments.
And they
then
still oppose
gets
it.
to the floor, and I got floor notes opposing the bill. And I make those amendments, and I get to Senate committee, and, supposedly there's going to be no opposition because I made these amendments, and the new opposition comes up. So it's really, it's been challenging, but I really think that this legislation is much needed, and I think it'll do a lot of good. And I understand, a lot of our members in this legislature don't like to put any type of restrictions on business, and I get that, right? My question is, where do you want these people to live? We don't want homelessness. I think everybody in here would say we want to deal with homelessness and do whatever we can to eradicate it. But if I have a security deposit in my pocket, if I have a pretty good credit score, 750, I think that's pretty good for rental purposes, and I got enough money to pay the first month's rent, and you have units available, but I can't get it because I have this thing on my criminal record, where are they supposed to live?
That's my sentiments exactly. We always talking about the lack of affordable housing, the homeless population, but we also talk about wanting people who have paid their debt to society to be able to come out and then be positive contributors to society. But how can they if the basic human right is not allowed to be met, which is simply finding a roof over your head or your family's head? And Mr. Chairman, I am sure there are plenty cards and buttons pressed, but I would like to table my motion to move House Bill 333 favorably with amendments. You got amendments?
No amendments.
No, okay. Move.
We have some amendments, but we haven't offered them yet. So if you would just hold that just for a little bit, I'm sure I'll give you the opportunity to do that when it's time.
Thank you, Reverend
Yes,
Noel.
ma'am. Let's go ahead and we'll take up the amendments.
Thank you, Mr. Chair. This is Amendment Set 1658. They are technical in nature, and there are 6 amendments in this set.
All right, I'll offer up those technical amendments. Any objection to the adoption of the technical amendments? All right, we adopt. We put them on. Adopted. All right, Representative Jordan with a question.
Thank you, Mr. Speaker. As I appreciate this is just more of a disclosure bill.
Yes.
So you're just letting people know if you're using a criminal background check, you're letting them know ahead of time so they can decide whether they want to pay that fee.
Correct.
And if you deny them because of the criminal background, then you let them know because maybe that's not you, and you can clarify or you can explain or
Correct.
whatever.
Exactly.
Pretty much the extent.
There's some insight into the process.
All right. Look, I think it's a good bill. I appreciate it. I just want to make sure I got it clear because I didn't know exactly, and I've heard it before, but I'm not sure what all the opposition would be about it. Thanks.
Thank you, Rep.
Representative McMakin with a question.
Thank you, Mr. Chairman. Rep. Willard, 3258.1, which is right above this, done by Rep. Duplessis in 2021, already requires that they give notice of criminal history if that's going to be on the application. So how is this not duplicative of what we're already doing in statute?
Now, did you read that statute? I'm not exactly sure what that one was doing, but I think that was dealing with state dollars.
This is the one you're adding to this section. It's right above yours.
Trying to pull it up.
Okay.
So are you referring to number 2 where it says they have to let them know if they consider a criminal history?
Mm-hmm.
Yeah. So, I mean, if that's your issue, that portion is already provided for, I'm happy to remove that on line 13 and 14 on page 1. Because in 13 and 14, that says they have to let them know if they consider criminal history for eligibility.
And specifically, too, this bill requires that if they are going to consider criminal history, this just says, will you consider it, yes or no? They're required to do that under the Fair Credit Reporting Act as is. They have to give you minimum Fair Credit Reporting Act information if they run your background check. This list would be, we will look at the last 10 years of your criminal history, and these specific offenses will not be admitted as tenants into this facility or into this property. So they could say things like, we will look for violent felony convictions in the last 7 years or the last 10 years. And we're not restricting that ability to eliminate or to restrict based on criminal history if it's reasonable. But it would be that if that person knows then, on my record, I have a felony from 5 years ago. This is not the place for me to spend my money. I'm going to apply right now because pursuant to their rental parameters, I know I would be denied. I will not spend my money on the front end. I will look someplace else.
Another example, someone a few years ago could have been caught with an ounce of marijuana in a felony conviction for that. And, it could have been expunged. It could have been, pardoned. They could have received clemency. Without this bill, none of that becomes part of the conversation.
Two more questions for you. So since this bill was enacted in 2022, I'm curious, your data and what you're talking about, have we seen this bill that's been enacted, have we seen the research of this one, and if your bill is even needed anymore? I mean, you said you've brought this up several years now.
Yeah, so there's no teeth in the bill that you were referring to. This bill gives it some teeth. And it gives some insight as to why somebody would be denied. And it allows an applicant, before they submit an application fee, to have some type of dialogue with the complex. None of that happens right now. The complex will say, sure, we consider criminal records.
So on those teeth, in the current statute, no person shall have a cause of action. Page 3, lines 4 through 9, you do create a brand new cause of action with your legislation. Is that correct?
It's some teeth. And guess what? If you wanted to work on it, I don't know what issue you're opposed to in the bill or if you're just opposed altogether, but if you have issue with the cause of action, I'm willing to work on other mechanisms to make sure that this law can be properly enforced. And just to piggyback on it, I'm going to read it. It says, a court of competent jurisdiction shall award an applicant costs of application fees plus $500 upon determination that a housing provider failed to comply with subsection F. A court of competent jurisdiction may in its discretion award costs and reasonable attorney fees to the prevailing party in action brought pursuant to this subsection. We've already passed bills off the House floor this session with this language.
And to the question about testing, yes, the data that I provided from the Louisiana Fair Housing Action Center was from January and February of 2022 after this bill went into effect.
Thank you.
All right. I don't see any more questions. I do have some green cards in support. And I'll just ask, if you have something to add that we haven't heard, please come up and feel free. We just need to make sure it's some kind of new information. Miss Sarah Whittington?
That was me.
Oh, I'm sorry. Okay, well, you did good. Mr. Peter Robbins Brown with the Louisiana Progress Action.
Good afternoon, everybody. Thank you so much. Peter Robbins Brown with Louisiana Progress. We just had a crime special session, of which I'm sure everybody remembers, even though it does sometimes feel like it was a long time ago. We were talking a lot about public safety, improving public safety. It's a serious problem that we have to deal with in Louisiana. We do have relatively high crime rates. One of the ways that was discussed about dealing with this was that we heard the term the revolving door of the criminal justice system was a term that was thrown around quite a bit. Helping people escape the gravitational pull of that revolving door is something that I think we should all be trying to move toward. And when we look at how that happens, the two most prevalent factors for people recidivating are lack of quality jobs and lack of quality housing. And so this piece of legislation in front of you today speaks in a very important way to not just an issue around housing, but an issue around public safety writ large. If we can help folks who do have criminal records find adequate housing, and this isn't the silver bullet, this isn't going to change everything about this and make it perfect, but it does help remove some of the barriers that people with a criminal record might face when looking for housing. It's also obviously speaks to their financial situation when we talk about application fees potentially piling up. And so I think that while it's obviously important that we think about this in terms of housing and in terms of economic impact and all the things that have already been discussed, and I think you'll hear some other aspects of this, that we also understand this as a piece of the ongoing effort to improve public safety in Louisiana, and a really important part of that in a way of sort of balancing what has been a sort of harsh back-end approach to public safety and crime, which obviously folks thought was necessary, with a little bit more of a front-end positive. How do we help folks who do have criminal records get back up on their feet and find the opportunity that they need to rebuild their lives and make a go for it once they've left incarceration. Thank you very much. Happy to take any questions.
All right, Representative Knox with a question.
Thank you, Mr. Chairman. Mr. Peter, do you live in New Orleans?
I do.
Where exactly do you live?
Mid-City, Bayou St. John. I'm in Redmond's district.
Mid-City, are you aware that I represent District 93?
I am very aware.
In District 93, we recently closed an housing encampment along North Claiborne that had about 100 people in it.
I am very aware of that, yes.
Are you aware of the encampment that was located near the convention center that had almost 200 people?
Yes.
Are you aware that I worked in the homeless program with the Department of Veterans Affairs?
I am.
Are you aware that there's always this talk about a less housing stock in my district of New Orleans?
Yes.
Are you aware that it has less to do with the housing stock, but more to do with the discrimination of housing homeless people?
I would tend to agree with you on that, although I don't have the data necessarily, but yes.
Are you aware that I am a business owner?
I am.
Are you aware that I'm pro-business?
I am.
Are you aware that I have no issue with disclosing to a homeless person that they have failed a criminal background check to live in my unit?
I'm not aware of that, but I certainly take your word for it.
Does it even make sense from a business standpoint that I would gain revenue by retaining a $25 application fee as if that's going to make me rich? Does that make any sense to you?
It doesn't, and I would also add that most application fees, especially these days with inflation, are far above $25. And so when you're talking about somebody with a low income, even $25 can be prohibitive. When we start talking about those higher numbers, it gets worse.
So I'm pro-business. I own a business. I own a housing unit. I worked in homeless program. I worked for the city. I worked for the state. I worked at the federal government. And all of what we're talking about today has simply to do with disclosing to an applicant as it relates to why they're denied a housing. Is that correct?
Yes, that's correct. And I would just say that in general in life, if there's something you're afraid of disclosing, that might speak to another issue.
Do you have a reason why someone would have an issue with disclosing that simple fact that they were denied housing based on a criminal background check?
I don't know what's in people's hearts and minds. I don't like to speculate. I have a hard time understanding why, right? But I'm also not in that position, so.
Well, I'm a business person, and I don't understand why a business person would be opposed to this. Have you seen any research to explain why someone in business would be opposed to it?
I have not, but I'm sure there'll be a few folks to come up and try and explain.
Are you familiar with this bill in this former version?
I have been in the negotiations for the past 3 years.
What did you find were the issues that made people averse to this?
Boy, we've had a lot of discussions. It would be hard to go through all of them, hours and hours. I can say that when we started 3 years ago, let's say we were over here, okay, and our opponents were over here. We have moved over 3 years all the way over here. There has not really been any give on the other side. We have really gone out of our way to try to find something that we thought was doable. And as Rep. Willard mentioned, he's obviously willing to continue to work with people. I think as long as the ultimate legislation has some teeth to it, right? I think that if the ultimate thing is that, in order for it to pass, it's meaningless. I don't want to speak for the author, but that's a little frustrating. But we've moved a long way, and I think we've hopefully found a way that this should work.
Thank you. And I'm not trying to ask any rhetorical questions. The questions that I'm asking are very sincere, and they're sincere in the fact that in my district of 93, we have a homeless crisis. If you go anywhere in New Orleans, particularly downtown, if you come down the I-10 to North Claiborne, if you go near the convention center, if you're in the warehouse district, if you go near Canal Street by Bourbon Street, if you come around the Marigny, you're going to see homeless encampments. And a lot of those people are there, 1, because of drugs, 2, because of criminal, 3, because of mental issues, and 4, because they can't go to housing because they are being discriminated against. Are you aware of that?
I am aware of that, yes.
So for the life of me, as I sit here today, I'm trying to understand and comprehend why for the last 2 years there have been some issues with this bill. As a business person, as someone who works in homeless, as someone who deals with this issue on a daily, I'm trying to comprehend what is the root of the issue as it relates to this bill.
I've been trying to comprehend that for 3 years.
Well, maybe one of my colleagues could tell me, because I truly don't understand, and it's a simple disclosure bill. It's simply stating that you have been denied to live in my unit because I don't approve of this criminal or this crime that you created. Therefore, I'm not even going to give you your money back, because as this bill states, I don't have to give you your money back because I'm disclosing to you why you're not getting my unit. Is that correct?
I believe so, yes.
And if I don't disclose to you and I just take your $25 and stuff it in my pocket and say, you're denied, then and only then that applicant has some recourse against me. Is that correct?
That is correct.
Thank you for the clarification. I appreciate it.
Thank you.
All right, I don't see any more questions for you, but I will tell you, I will just chime in on this, Representative Knox. You can file a local bill, and if you have an issue specifically in your district, to address those. So I'm just throwing it out there.
Can I respond to that?
All right, I have a couple more cards, and again, please, if you have some additional information, we would love to hear from you. If it's repetitive, maybe just wave. Bruce Riley would vote.
Thank you, Mr. Chair, members of the committee. My name is Bruce Riley with Voice of the Experienced, and I'm here to tell you something that you already know, which is obviously that people are being discriminated by the thousands and not giving a fair chance. But the thing that makes this situation, especially egregious is you're being asked to pay a fee, and you might be a winner. It's actually probably an illegal lottery, right? You might be accepted in. You're not being told ahead of time your odds of being accepted in, the criteria of whether you're eligible. And that is the part that's just the most egregious. It'd be one thing to say, as was mentioned, this specific type of crime, the specific look-back period, and then you could know ahead of time whether you're going to spend your money on that. And in terms of the money that it costs to do these background checks, for $30, I can run background checks on all of you in about an hour. Now, they may not be actually very accurate. They might be accurate. You tell me. I could find out about your property holdings, about your LLCs, speeding tickets you might have that are out there, and it might actually be a different Boyd or a different Carver. Maybe it's your brother or your sister, and it was close, right? But that's the one that I ran after you gave me the $40. But I have a $30 monthly thing where I can run on all you people, unlimited. And so this idea that it costs $40 to do a background check is just terrible. And if you're in the business of doing these things, if you are a landlord, especially a corporate landlord, how many different applications fees are you processing over the course of a year? And so really the fees, they turn into like a barrier for entry. So if it's like, oh, well, you don't want to pay the $40 fee? Well, I guess $40 means a lot to you. Maybe you're not wealthy enough to live here. Well, maybe I just don't want to pay to 15 different places and hear all these horror stories, and then I'm out all that money. As someone who has a criminal record, I've never been asked for my background check at any hotel I've stayed at. And I recently just purchased a home, and I didn't get asked for a background check for that. But I've been denied at so many places trying to rent rent an apartment, even though every single one of my neighbors had said, I'm the best neighbor ever. I get the mail. I water the plants. I do all the little things. I'm there. I'll feed the cat. I love being a good neighbor. And likewise, I love when I have good neighbors. And it has nothing to do with what happened when I was a teenager. It has everything to do with how I behave myself now. And if Louisiana can't build a housing situation where people with money, with a job, who are trying to get housing can't get it, well, how are you going to help the people under the bridge? If you can't help people that got their own money and their own job, people like myself that have to get that denial and then say, you know what? You go to a club enough times, they say, we don't let you in, you don't even try going to that club anymore. You're like, I don't even want to go there anyway. And then we start getting into more tension and more people becoming antithetical to society. We need to be encouraging people to be paying rent, not trying to push them away. And I would suggest that folks that don't want to deal with maybe what they might see as a challenging tenant, a challenging business client or whatever, maybe they're in the wrong business. Maybe they should invest their stuff elsewhere, and they shouldn't be investing in housing. They should invest in gold. They should invest in crypto. I don't know.
Well, thank you. We appreciate your testimony, sir.
But my point, I'll just close
Thank you. We
with that.
appreciate your testimony.
Yes,
we have
thank
a few other cards. And again, if you have something specific to this, we would like some new information. We do have to go on the floor. We're asking you to be respectful of the committee. I'll take up both Benjamin Zucker and Earl Haggins. If you want to both come up at the same time, that would be great if you have something to add.
Good morning. Thank you, Mr. Chair and members of the committee, for allowing me the opportunity to testify today. My name is Ben Zucker, and I'm a co-director of Step Up Louisiana, and I'm asking you to move favorably on House Bill 333, a consumer protection bill to inform housing applicants and benefit landlords. The opposition to this bill has come from the Apartment Association. Why would landlords who are trying to do the right thing be opposing this bill? This bill gives landlords additional liability protections, like protecting landlords from liability if they rent to someone with a conviction, if they do not conduct a background check, or liability protection from storing housing applicant information. This bill will save landlords money so they are not wasting time interviewing and processing applications for individuals who will never be accepted because of their background. This bill will make our neighborhoods where the landlord's properties are safer because to help formerly incarcerated people be housed more quickly so they can focus on their housing search on the rental properties who want their business. With all of these benefits to landlords, safer neighborhoods, saving time and money, and liability protection, why is the Apartment Association opposing this bill? It can only be for one reason. The Apartment Association is opposing this bill because they are trying to protect a small group of bad actor landlords who use the application fees as a revenue stream. In the worst cases, some of these bad actor landlords are using the application fees as a predatory scam. Bad actor landlords are using the application fee money for more than just to pay for a background check and any other necessary costs. Bad actor landlords are using the application fee to make profits. HB 333 very simply requests that if you're going to categorically deny someone for a certain type of conviction, you let them know that you plan on doing that to save everybody time and money. In closing, this bill is a consumer protection bill. 1.5 million Louisianans have some sort of conviction history. Protect those who are trying to do the right thing. Protect the 1.5 million people with convictions trying to find stable housing. Don't protect the bad actor landlords or the Apartment Association. Thank you.
Thank you, sir. And Mr. Earl, would you like to say a few words?
How y'all doing? My name is Earl Higgins. I'm a formerly incarcerated person. However, you wouldn't know that by just looking at me. Here's what I pray for. I pray that this legislative body, the people, you all have the compassion to do what's right for people less fortunate. I'm in a position right now today in my life where I'm homeowner. Been to prison. Went to prison 5 years. Came home. Tried to get rental. You go to jail, come home, do the right thing, blah, 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 blah. I did all of those things, and you know what happened? Door slammed in my face. I'm a homeowner today because I have compassion for people that feel like I feel. I don't know if y'all understand what I'm saying. Maybe you all don't understand where this is coming from. It's the only thing I could think of. I don't have to be here today. That's what I'm saying. But I know the feeling of people telling me after I get sentenced, do my time, and they say, well, when you come home, you get your job, you'll be able to secure housing. They tell you all these things. That's what they tell you in the courtroom. But the collateral damage of when you come home is that, have you ever been convicted of a felony? And as a consumer, there's this place, Ollie's, on Lapelco, good stuff cheap. And in this place, you might find some good stuff. It might be, and it will be cheap, but because of how they market it to the consumer, you know going in that you might run a risk of not getting great stuff cheap. Basic information. That's all I'm asking for as a consumer. Let me know, because I'm trying to keep it together because I get a little bit emotional, and I be wanting to say some other stuff that y'all might not appreciate. And I heard you say keep it respectful, and I don't mean no harm when my emotions run. I'm just passionate about this because of that feeling that I felt when I came home of being told no, even though I was in a proper position to secure housing. And it was only because I had been to prison. I pray that I love this man, Matthew. I love the man because he represents what legislation should be about. Compassion for the less fortunate. But I think I'm gonna shut up now, because if I keep going, I might wreck future opportunity to come and sit and talk to you all. Y'all are a lovely body, and I pray that you just have some compassion for the less fortunate. So, basic information.
Well, thank you for coming today. We appreciate your testimony, and it was obviously from heart, and that's what I was asking for. It was from testimony such as yours. So I appreciate you sharing that story with us. I don't see any questions, but we had several members ask about the opposition and why they're opposing it. They are here. I'd like to let them speak before we go any further. If we could do that, Representative Mina? Okay. Unless you have something quick. All right, Mr. Jim Bether with the Apartment Association, and Miss Tammy with the... How do you say your last name, Mr.
Esponge.
Esponge? I'm from Balls Parish. We don't have a lot of Esponge. Sorry. All right. Floor is yours.
Thank you, Mr. Chairman, members of the committee. My name is Tammy Esponge. I'm the Association Executive for the Apartment Association of Louisiana. We represent about 750 members, consisting of about 150,000 rental homes throughout the state of Louisiana. We are opposing this bill, as Representative McMakin referred to. We already have and worked with, at that time, Representative Duplessis, that we have to disclose what our screening process is, whether it's credit, whether it's income, background check, et cetera. We do educate our members as far as best practices, fair housing laws go. We do not support bad acting landlords. We always educate to do the right thing and do the best operations and best practices in operating your properties. As far as application fees go, many of our owners, not all, but many of them do have to pay. They pay for third-party screening companies. So there's a fee involved as it relates to, not everyone. Some owners don't even do criminal background screening. Some do, some don't. So there is a fee involved if they're using third-party screening companies. And even if they're not, maybe they're going directly through Equifax or whomever it is, there are fees involved when you're running credit screening, whatever it may be. One thing we did do as an organization when this all came about a few years ago, we surveyed our membership asking what is the thing you deny most of your applications on. And about 98% of our members came back and said they denied applications based on credit and or income. So around 2% of their denials were based maybe on criminal screening. So that's kind of where we are. I'm going to turn it over to our attorney for any other comments or if you guys have any questions.
I'm just happy to answer any questions that anyone has.
I do see one question from Representative Green.
Mr. Chairman, did you have something you want to say?
Yes, sir, I will. Listening to this and Representative listening to the whole, I guess, debate and speaking with Representative Willard over the last few weeks, listening to it last year, I can see that there's probably some places where we do have some bad actors in this whole process, and I guess, I know we can't, create laws and for the only the 2%. So I guess my question is, Representative Willard maybe feels like he didn't get a lot of cooperation. Are y'all at an impasse at this point where we just don't think there's anything that we can possibly do? Are we fundamentally just that far apart? And then maybe I shouldn't be asking this. Maybe I should ask Representative Willard the question. But, I just want to hear from you what your thoughts are. Is there some other things that can be worked out, or is this just one of those issues that we agree to disagree on?
Well, in the past, we have worked with Representative Willard on one version of this bill, and this is a different version. There is a fundamental disagreement. We oppose any new causes of action that would make operating apartments more expensive, and those costs will be passed down to residents in the form of higher application fees and higher rents and tighter credit screening requirements. So there are some fundamental disagreements. We have worked with him in the past, and we've kind of reached an impasse. Does that answer your question, Representative?
Yes, sir. I'm just trying to make sure that we where we are now because of we worked together and we tried to come up with some solutions. Obviously, there is an issue. So that's really what my questions were about. Just trying to figure that.
We have worked with it in the past, and we did reach an impasse.
So the only other thing that I want to maybe understand is, if we start getting to a point where we're asking these landlords to start disclosing certain things, why they do things, why they didn't do things, would there be a potential for maybe having stricter guidelines and basically saying we don't want any convicted felon because
that could be a problem, a fair housing problem. I don't think a landlord would say that necessarily, but it could lead to tighter restrictions on credit if there's going to be new risk introduced on the criminal screening side. They're going to have to compensate for that with tighter credit screening requirements and maybe higher application fees, higher rent. So I believe there will be unintended consequences. There are intended consequences and unintended, and I think that would be an unintended consequence of the bill.
Okay, thank you. Representative Green?
Thank you, Mr. Chairman. I didn't get your
Jim
last
Rather, I'm sorry,
Jim
sir.
Rather?
Yes, like Dan Rather, but I'm Jim.
Okay. Thank you, Mr. Rather and Ms. Esponge, for being here. So my question is, so I'm looking at the statute that governs residential lease application requirements. And so basically, the lessor shall not require payment of an application fee prior to accepting the payment unless the lessor gives written notice of basically three things. Number one, the amount of the application fee. Number two is the consideration of factors, which include criminal history. Yes. And three, that there's an option for the applicant or the lessee to provide a hardship statement. Is that correct?
Yes, sir. You're referring to 3258.1?
That's correct.
That's correct. Yes, sir.
So that's just basically the factors that they have to provide that, hey, look, before you even pay this fee, these are things that we consider, which I'm fine with, right?
Yes, sir. Before we accept a fee, we have to disclose the things we consider. That's correct, sir.
So if criminal history is a factor that the lessor can consider before or after they accept the application fee, then why shouldn't the lessor give some type of notification to the lessee if, in fact, that individual was denied housing on the basis of a person's criminal history?
Sir,
which I think is what this bill attempts to do.
Sir, if I'm not mistaken, the Fair Credit Reporting Act does require everyone to give an adverse action letter. That's federal law, it's my understanding. And I believe that letter has to give the general reasons for the denial. Now, I'm not an expert on the Fair Credit Reporting Act, but I believe that's the case. If somebody is denied, if their application is denied, the Fair Credit Reporting Act does require in this case, the tenant receive a letter with a general reason for the denial.
Under that particular statute, I haven't seen it, I'm sorry.
And I'm not an expert on it, sir, but I believe that's the case.
Is there a provision in there that deals with the application fee or the reimbursement of the application fee to the applicant?
I don't believe so, sir, but I'm not intimately familiar with the Fair Credit Reporting Act.
Okay. Is there a enforcement provision in that particular federal statute?
From what I understand, yes, sir. I mean,
and what is that enforcement provision?
I don't know the details, sir.
Is it stricter than the one that's contained in Representative Willard's bill?
I can't answer that question. I'm not intimately familiar with the Fair Credit Reporting Act.
Okay, thank you.
Thank you, sir.
All right, I don't see any further questions. We appreciate you coming today. And Representative Willard, if you'd like to close on your bill.
All right, thank you, Chairman Deschatel. I was just told that the opposition just said that the Fair Housing Act at the federal level requires complexes to tell you why you were denied. It does not. If it did, we wouldn't need this bill. Just a couple of things that I want to bring up. We've heard a lot of talk about Senator Duplessis's bill and an argument being made that we don't need this bill because of that bill. Senator Duplessis brought his bill to let potential applicants know if a credit score, if an eviction history, and employment history is part of the application process. Complexes have to tell you if they screen for criminal records. That's federal law. If they don't tell you, and we've been hearing a lot about a new cause of action, but let me tell you, the litigation already happens. Today it happens in a federal court. So when violations of the Federal Fair Housing Act occur, it happens in a federal court. So the litigation is already going on. There's no penalties provided in state law by Senator Duplessis's bill. We can't make, and I know Chairman Deschatel, you brought up a good point. You said, well, could this possibly lead to more restrictive guidelines? But it can't. Federal law, the Federal Fair Housing Act, says that you can't do blanket bans. That was part of those two sentences I read to you in the beginning. You can't do it. If you do, you open yourself up to federal litigation. These blanket bans still happen in Louisiana, which is why this bill is needed. Complexes all across the state deny people just because they have something on their criminal record, just because something comes back in that background check. And guess what? They still have to pay that application fee every time because they need housing. Members, we just spent a few weeks during a special session, the second extraordinary session, debating bills related to crime and public safety. One thing that we did not discuss during those 10 or so days was recidivism. We did not talk about recidivism. And when you have a conversation about recidivism, you have to talk about workforce development. You have to talk about job opportunities. You have to talk about treatments for mental health and substance use disorders. And you gotta talk about housing. You have to. If a person can't provide for their basic necessities in life, they're gonna go back to what they know, and at the end of the day, which is somewhat comfortable. And I think that is a situation we all want to prevent. Because many times those environments foster crime, and when crime is fostered in our communities, what happens? More crime is committed, more victims of crime are created, people are caught, they go into our prisons, and taxpayers have to spend more money because we didn't rightfully address recidivism. I think HB 333 is a great step in the right direction. Like I said, I'm happy to work with each and every one of you on any issues that you have, any ideas you have on making this a better bill. But I think this is a great start, and I would ask for your support to report this bill favorably. Thank you.
Well, thank you, Representative Willard. Just one last point I'd like to make. You know, if on your last page, you said, for the purpose of this section, housing provider shall mean an owner, leaser, subleaser, property manager, or property management company that leases or rents residential property. So we're not talking about large apartment complexes only. We're not talking about...
We could.
But we're not. We're talking about every single person who has a rental property in the state of Louisiana, which I can assure you is a whole lot more people than that owns large apartment complexes. Mm-hmm. People like myself, I have several rent houses. There's a lot of people in my community that have rent houses, which is how our community... a lot of people live is through rental. So there's a lot of people that this bill affects, and I just wanted to point that out. You know, I know you're trying to solve a specific problem, but it's, you know, you're bringing in a lot of people to the conversation. But that was just my comment.
Would you give me 1 minute, please? Could I have one more minute?
Yes,
okay.
sir. I'm sorry.
I appreciate it. So. In the past couple of years, I brought this bill. Nobody's ever brought that up. I would be totally fine only applying this to larger complexes, even if you set a certain limit to it. The apartment association said that they feel like we are at a standstill, that there's no room to negotiate on this. I'm always, I mean, if you know me up here, you know I'm always willing to work with stakeholders and consider opposition. In 2022, when I first brought this bill, they did work with me, but the only reason they worked with me was because I was able to get this bill out of committee and then get this bill off of the House floor. So they worked with me in every step of the process on amendments that they said if we make these amendments, they will remove their opposition. I made the amendments. They came up with new opposition. The goalpost moved every time, but the only reason they came to the table was because I was somewhat successful at advancing this legislation forward. So I just wanted to add that. I appreciate you allowing me that courtesy.
Yes, sir. Thank you. All right. Manuel made a motion to report House Bill 333 with amendments. And we have an objection by Vice Chair Thomas. Madam Secretary. Sorry.
Chairman Desato?
No.
No. Representative Boyd? Yes. Representative Carver? No. Representative Cox? Yes. Representative Davis? No. Representative Domain? Yes. Representative Green? Yes. Representative Abear? No. Representative Hilferty? No. Representative Jordan? Yes. Representative Knox? Yes. Representative Landry? No. Representative McCormick? No. Representative McMakin? No. Representative Mina? Yes. Representative Noel? Yes. Representative Reiser? Yes. Representative St. Blanc? No. Representative Thomas? No.
10 noes, 9 yeas.
Thank you, members.
Thank you.